Clerk will report a floor amendment.
Yes, sir, Mr. Speaker. Floor amendment to House Bill 30, offered by Delegate Ebbin. Item 4-6.071H, page 422, after line 5, insert Section 4-6.07, discharge or layoff of state employees. No employee of the Commonwealth, including employees of public institutions of higher education, shall be discharged or laid off from employment based on his race, color, religion, national origin, sex, pregnancy, childbirth, or related medical conditions, age, genetic information, marital status, disability, sexual orientation or gender identity, or status as a veteran. Any employee discharged or laid off in violation of this subsection may bring an action pursuant to Section 2.2-2639C of the Code of Virginia and recover back pay and attorney's fees as provided therein.
Gentleman from Alexandria, Mr. Ebbin.
Mr. Speaker.
Thank you, Mr. Speaker.
Mr. Speaker.
Gentleman from Prince William, Mr. Marshall.
Point of order.
Gentleman may state it.
Gentleman, there was a litany of why you can't be discharged, and then he added an affirmative duty to authorize lawsuits. Is not this legislation on an appropriations bill in violation of our rule of one object?
Mr.
He's just stating what's already in the code. That's already provided in the code, that you can recover back pay and attorney's fees.
Okay, thank you.
Okay. Gentleman from Alexandria, Mr. Ebbin.
Thank you, Mr. Speaker. This is a jobs amendment. We are this is also one of your final chances to pass an amendment for a regular House member. In this budget, we're forced to adopt reductions in funding that could lead to the layoff or discharge of hundreds of employees across the state in government and in our colleges and universities. These employees have no meaningful protection from layoff or discharge based on factors other than merit, including the ones that were just read aloud. Although all state employees should have some protection from discrimination under the governor's executive order, our new governor has removed protections previously provided for the state's gay, lesbian, bisexual, or transgender employees, saying that it is up to the legislature, us, to set the state's policy in this regard. It's time that we do that. Even if applicable, the executive order offers little in the way of remedies for an employee who loses his or her job through discriminatory action of a single supervisor. Finally, state employees have little protection from discrimination under federal civil rights laws because of a series of Supreme Court decisions that have interpreted the 11th Amendment to the Constitution as providing state immunity from suit in federal or state court for violations of the Federal Civil Rights Act, the Age Discrimination Act, the Americans with Disabilities Act, and the Equal Pay Act. It's been the policy and practice of the Office of the Attorney General for at least the past 10 years to aggressively assert that this immunity defense, in all discrimination cases brought pursuant to federal law by state employees. This budget amendment does no more than extend to state employees the same limited right to seek redress for discriminatory discharge that the state has extended to private employees and businesses with 5 to 15 employees who also lack federal civil rights protections. We've heard a lot about what's good for the goose should be good for the gander in the context of debates about extending mandated benefits to both state and private employees alike. It's time to assure that our state employees, that as they face the uncertainty of the current economic and budget crisis, that we believe that they should be protected from discriminatory discharge just like their peers in the private sector. It's not only the right thing to do, it's the best business practice. It's an action supported by almost 90% of Virginians who agree that even gay, lesbian, and transgender people deserve protection from workplace discrimination and the right to work for the government. Let's do what we know is right and what the overwhelming majority of Virginians want and expect. I urge you to adopt this amendment.
Gentleman Prince William,
Mr.
Mr.
Speaker.
Marshall.
I move to pass by the amendment, and I'd like to take a portion of the 2 minutes allotted to me under the rules.
Gentleman has the floor.
In arguing for the amendment, the gentleman presented no information that, in fact, any of the classes of individuals which he cites to be protected against so-called discrimination are, in fact, being discriminated against. So I do not think this is necessary at all, and I'll yield a balance of my time.
Thank you, Mr. Speaker.
Gentleman from Alexander, Mr. Ebbin.
Thank you, Mr. Speaker. Speaking to the motion to pass by the amendment,
Gentleman has the floor.
I would contend that providing evidence of discrimination for any of these categories, whether it's gender, race, or religion, or sexual orientation, is not necessary, particularly when many people are afraid to come forward and be open about their sexual orientation or gender identity. I would hope that we defeat the motion to pass by.
The question is on adoption of the motion to pass by the amendment. As many as favor of that
Speaker.
motion.
Sorry.
Gentleman from Alexander, Mr. Henry.
Parliamentary inquiry, Mr. Speaker.
Gentleman, state it.
Mr. Speaker, if an individual votes in favor of passing by this amendment, then would I be correct in saying if that motion passes, the amendment is no longer before us? So in effect, a vote to pass by the amendment is the equivalent of voting against this amendment.
Not necessarily.
I thank the Speaker.
The question is on the adoption of the motion to pass by the amendment. As many as favor of that motion will say aye. Aye. Those opposed, no? No. Chair's in doubt. As many as favor of the motion will raise their right hand. Oh, I think that's sufficient. Shall the motion to pass by the amendment be agreed to? Clerk will close the roll.
Ayes 61, noes 38.
Ayes 61, noes 38. The motion is agreed to.